This is the Thursday, November 13th, 2014 meeting of the Zoning Board of Examiners and Appeals. Could you call the roll, please?
Mr. Vig?
Here.
Mr. Cars?
Here.
Mr. Ron?
Here.
Ms. Eicher?
Here.
Mr. Hart?
Here.
Ms. Dole?
Here.
Ms. McKay?
Here.
Thank you.
We have before us minutes from two meetings, the Thursday, September 25th, 2014, and Thursday, October 9th, 2014 meetings before us for approval. Could I have has everybody had a chance to review the minutes? And, if so, could I have a motion to approve, please? Yes, Mr. Vig?
I move to approve.
Thank you. Ms. Eicher, you've seconded?
I do.
Thank you. Ms. Dole?
I was not at the meetings and plan to abstain unless that's a problem.
Thank you, Ms. Dole. Mr. Ron?
Thank you, Mr. Chair. Similarly, for the record, I was not in attendance at these meetings and would be abstaining from approval of the minutes. So hopefully that doesn't put us in a short board situation.
Okay, thank you. For the record, I've been informed that while you weren't present, you can participate and vote of the minutes, just not the resolutions. However, I don't think that's an issue since we do have a quorum, but, without your participation. Are there any other comments? Mr. Vig?
Yeah, Mr. Chairman, in the October 9th meeting minutes, item D, number 2, the action was postponed. It says to the November 19th meeting, but I think that should be the 13th, the meeting we're at this evening. That was the only change that I saw.
Thank you, Mr. Vig. Ms. Eicher, you have any objection to that change?
I don't.
Thank you. Are there any other comments? Are there any objection to approval of the minutes as revised by Mr. Vig? If not, those minutes are approved. Moving on to our next item on our agenda are disclosures. Are there any disclosures this evening? Yes, Ms. Dole.
With regard to resolution 2014-011, the public hearing for that was during the October meeting, and I was not present, so I will abstain from that. I have not listened to the tape on that.
Thank you, Ms. Dole. Mr. Ron.
Thank you, Mr. Chair. I similarly was not in attendance at the October board meeting and will be abstaining from voting on resolution number 2014-011. I did not listen to Granicus. I'm not going to vote. You can't make me.
Thank
you, Mr. Ron. Yes, Ms. Eicher.
Thank you, Mr. Chair. I was not present at the meeting where resolution 2014-007 was heard, and I will be abstaining from voting on that matter.
Thank you, Ms. Eicher. And Mr. Hart.
I also was not present at that same meeting. Will be abstaining from resolution number 2014-007.
Thank you, Mr. Hart. I believe with those people that will be abstaining on those two cases, we still have sufficient number of people in attendance to vote for approval of the two resolutions before us. Are there further disclosures this evening? Any other disclosures? Okay, thank you. That moves us on to our consent agenda. We have, again, before us this evening, two resolutions for approval on the consent agenda. Could I have a motion to approve, please? Thank you, Ms. McKay. And Mr. Big, you've indicated a second?
Yes.
Thank you. Is there any discussion, any further discussion? Is there any objection to approval of the consent agenda? Seeing none, the consent agenda is approved. Item E on our agenda this evening are appearance requests. We have no appearance requests. Item F is unfinished business and actions of public hearings. We have no agenda items under that item, nor under the regular agenda. That brings us to our public hearings this evening. We have two cases for public hearing. Before we hear our first case, I would like to read the order of business with respect to variance hearings. The chair shall introduce the variance and explain the procedure to be followed. The variance case number and the name of the applicant shall be read into the record. The board shall hear and rule on any objections to the sufficiency of notice. The board shall hear a brief staff presentation outlining the variance, not to exceed 10 minutes. On conclusion of the staff presentation, the board members and the applicant may then direct questions to the staff through the chair. The applicant shall give his or her presentation, not to exceed 10 minutes. Throughout the proceedings, the burden of proof rests upon the applicant, who must convince the board by a preponderance of the evidence that the variance should be granted. On conclusion of the applicant's presentation, the board members and the staff may then direct questions to the applicant through the chair. The hearing shall then be open for public testimony. Each person has 3 minutes. Representatives of groups have 5 minutes. All persons who testify may be questioned by the board, staff, or the applicant. On conclusion of the public testimony, the staff, followed by the applicant, shall have the right of rebuttal. The board shall proceed to develop oral findings and conclusions with regard to the variance and disposition of the variance. The staff shall reduce the oral findings and conclusions to writing for subsequent adoption by the board at a later meeting. The matter then rests with the board, and the chair asks for a positive motion from the board. I would like to explain for both of the applicants, I believe, that are here this evening, we must find, in order for a variance to pass, that it's a majority of the fully constituted board, which will mean that 5 votes are necessary in favor of a motion in order for it to pass. Our first case this evening is case 2014-0162. The applicants are Howard and Teresa Tees. Is the petitioner or the petitioner's representative here this evening?
Yes, Mr. Chairman.
Thank you. Could staff provide us with a sufficiency of notice, please?
Thank you, Mr. Chair. 94 public hearing notices were mailed on October 22nd, and no responses were received from the public or the Community Council.
Thank you. Would you proceed with your presentation?
Thank you. The petitioner is requesting a variance from the R1 district regulations to allow a 2-story house to encroach 1.2 feet, 6% into the 20-foot front yard setback. The encroachment was discovered when a new as-built was ordered to market the house for sale. In 2007, the property owner hired an architecture firm from Matsu Valley Borough to construct a building addition. While a building permit was issued for the addition, no final certificate of occupancy was obtained, and the building permit has since expired. The house would be eligible for an administrative variance if the encroachment was 0.9 feet or less, but it's over that. Standard number 1 does not appear to be met. There's no exceptional physical circumstance of the land. Standard number 2 does not appear to be met. there's no physical circumstance of the land which would prevent the owner from having a house on the property. The 1.2-foot encroachment, front yard encroachment, is due to a building addition that occurred in 2007. It appears that it was a construction error, and the building permit was never closed. Standard number 3 does not appear to be met. There's no peculiarity of the lot. The need for the variance is a result of the petitioner's desire to keep the existing two-story building, two-story addition on the home. The original house contained 1,198 square feet, and the addition added 120 square feet to the living room area. It's a living room area with a sort of a tall ceiling. Standard number 4 does appear to be met. The variance will not adversely affect any adjacent property. And standard number 5 is met. The requested variance is dimensional. It is not a variance for a category of use. Standard number 6 is met. The encroachment will not cause any fire separation, concern, or violate or clear vision area on a corner. None of the reviewing agencies have objected to the variance. The petitioner has provided letters of non-objection signed by the neighbors to the east and west of the petition site. Those letters are on page 22 of your packet. Standard number 7 is substantially met. The existing house encroaches 6% into the front setback. The encroachment is not visually obvious and appears to be minor. The department finds that standards 1, 2, and 3 do not appear to be substantially met and therefore must recommend denial of the variance. If after the public hearing the board finds all 7 standards are substantially met, the approval should be subject to conditions 1 through 3 on page 5. Conditions 1 and 2 are standard. Condition 3 says obtain an encroachment permit from the right-of-way division for the portions of the house and fence that encroach into the utility easement or remove the encroachments. So there's a 10-foot utility easement along, I think it's the east boundary, west boundary, and the corner of the house encroaches slightly, and the fence sort of crisscrosses across that utility easement. The way one resolves that condition is to obtain letters of non-objection from the affected utilities and then provide that to the right-of-way division who processes an encroachment permit. That's all I have. I'd be happy to answer questions, and the petitioner is here as well. Thank you.
Thank you, Mr. McLaughlin. Are there any questions of staff by the board members? Yes, Ms. Dole.
Through the chair, in the finding, in the explanation of finding number 1, it states that the property is relatively flat, but I noticed that the petitioner said that in the application for this variance that there was a steep slope at the rear of the lot, and I wanted to ask if you were familiar with the lot and just could address, had any thoughts on that discrepancy?
Through the chair, Ms. Stoll, I apologize. I did not photograph that southeast corner of the lot where the lot drops off steeply, and I did not provide a topography map either with 4-foot contours. Majority of the lot is flat, but there is a slope on the back right corner, the southwest corner of the lot. You can sort of see where that is by looking at the fence, location of the fence on the as-built, but there's no supporting documentation provided by either me or by the applicant in regards to that. I don't know what the slope is. I apologize.
Okay. I guess I do have one other question through the chair.
Yes.
I just wanted to guess I wanted to ask about the sizes of of typical houses in that area, given the references to the original house having 1,198 square feet before the building addition, and that being a small house for that area. Do you have anything further or additional, or am I stating that correctly or incorrectly?
Through the chair, Ms. Dole, that's correct. You caught, there was a statement made that the house was small as compared to its neighbors, I think, and that this addition sort of brings the house closer to parity with the neighbors. I can't dispute that claim. Fortunately, the petitioner's representative, I think the petitioners are out of state, but the petitioner's representative who is here is also a real estate broker and would be more knowledgeable than me at describing the square footage of homes on this block.
Thank you.
Are there any other questions of staff by the board members? I do have a question, Mr. McLaughlin. Do you know when the original home was constructed, or was that in the case right up and I missed it?
Through the chair, we have that information at our fingertips from the computer and our property tracking program, and I don't believe that that I included any of the property history information with the packet. It's not here, but the petitioner's representative explored non-conforming rights, and I'd ask that you direct the question to the petitioner's representative.
Yeah, okay, thank you, I will. Mr. Ron.
Thank you. Through the chair, Mr. McLaughlin, I'd like to draw the board's attention to page 13 of the staff packet, which is an aerial photo, number 2014-0162. We see the subject lot, and to the south of that, a large lot that appears heavily wooded. My interpretation of this aerial photo indicates that this particular petition's lot is in a unique position adjacent to that wooded lot. Could you comment to that effect? Is within this section of R1, is it common to see such a large wooded lot in close proximity to more dense residential areas, or could this potentially be a unique circumstance?
Through the chair, Mr. Ron, this is a pretty unique circumstance. Typically, you have sort of your collector streets, and bordering those, you may have some commercial zoning, and then behind that, you might have some RO residential office zoning or multifamily housing, and then as you get further away from collector streets and deeper into a residential neighborhood, then it gets closer to, say, an R1 single-family detached neighborhood, a sort of a subdivision like this one. This property to the south is some sort of non-conforming commercial greenhouse that may be unique in all the municipality. I think that property owner both lives there and runs some sort of business, but it's existed long enough that they're able to continue this use that wouldn't otherwise be allowed. There's a few examples of this in town. One of those that I can think of that many people know of, when you're driving along the Seward Highway, there's that tall black snow dump that's near Dowling Road, and it's bordered by residential houses on two sides, and that zoning, I think it's a residential zoning and doesn't allow a commercial snow dump, but it's been in effect for many, many years, and so it's allowed to continue. And I think that this is a similar sort of situation.
Thank you.
Are there any other questions of the board? Seeing none, if the petitioner could come forward, please. And could you state and spell your name for the record, please?
Yes, Mr. Chairman, my name is David Windsor. I'm an associate broker with Remax Dynamic Properties, and I'm here representing Mr. and Mrs. Howard Tees.
Thank you, Mr. Windsor, and that's W-I-N-D-S-O-R?
Correct.
Okay, and we have a letter of authorization on page 23 of our staff packet. So if you would, you can proceed with your presentation.
Mr. Chairman, may I present a small amount of additional material?
Sure.
Distribution, which will be explained in my presentation.
Sure. We will have to keep at least one copy for the record for 30 days. Okay. And again, Mr. Windsor, you have 10 minutes for your presentation.
Thank you. When I practiced, Mr. Chairman, it came out at 8, and I was really sweating to get through it. But thank you. Thank you, Mr. Chairman, ladies and gentlemen, for allowing me to be here on a rather awkward matter. My clients, Howard and Terry Tees, are both 66 years old and now residing in Washington State. They actually hired my services in July to market and sell their property, which is, I might say, a substantial portion of their retirement assets, and also required for medical expenses that they will have, since Mrs. Tees had a kidney transplant last year, and indeed that was the reason they needed to leave the state. They listed their home with me in July, and we promptly received an offer, which we thought was a miracle at the time. And I proceeded to order a new survey from Shane Holt, and I actually sent him out twice because the first time I couldn't believe that he came up with 18.8 feet setback. But nevertheless, he's quite certain of his work, and I have every confidence in it. I then discovered that not only was there an encroachment into the front setback, but that the extension permitted in 2007 had never been closed out as a permit. Mr. Chairman, my clients had hired a professional architect in town to design and guide them in this process. They were meticulous about that, and indeed, sir, they are meticulous and honest people. Together with that Land Tech survey on the top of that additional material, with the hand-drawn rectangle prepared by their professional architect, they came to the municipality and applied and were granted a permit. You will notice that the hand-drawn rectangle states 20 feet from the front setback, and not prepared by a professional surveyor, but attached to the architectural drawings which they adopted. The first letter attached to that package, and I'm giving you that survey because it, of course, is the one that they assumed was being proceeded upon. The first letter is from the original Valley builder Genesis contractors, and he claimed that he had built it precisely to the architectural drawings. Of course, that's just a letter, but in seeking to close out the permit over the last few weeks, and we got the electrical signed off. I reopened the permit. we got the electrical signed off, and the structural inspector from the municipality insisted that we expose the foundations to just satisfy himself with regard to the structure. And during the course of that, we also hired David Fritz, engineer, to be present. And the second letter attached to that survey at the back is from the current contractor, whom I know personally, who attended the property, removed the siding, was present with the civil engineer, and testifies in writing there that the structure was built precisely in accordance, precisely to the exact measurements of the architectural drawings. And I'm only saying this, not of course to satisfy any standard that you may have to grant a variance, but to let you know that my clients were somewhat naive. I'm sure it happens, but innocent in the sense that they also would most assuredly have gone for inspections and the closing out of the permit had they known and been advised that that's what they were required to do. But they had the architect design, they submitted for the permit, they had Genesis construct the extension precisely per the architectural drawings. And I can answer further questions on that if required. As regard the standards, I'm aware of the 7 standards that are required in order for you to pass a variance. I'm aware of the staff report prepared, and that items 4 through 7 might be less of a problem to this board. With regard to standards 1 through 3, which all relate to physical circumstances, it occurred to me in studying them that they appear to be designed for someone to come into this chamber and seek a variance prior to construction, and therefore arguing that there are physical circumstances requiring the variance in order to, for them to proceed with construction. And occurs to me that perhaps forgiveness was not really the intent, and so I find myself in an awkward position here. However, I would like to emphasize that indeed, if you look at either survey, particularly the most recent one by Shane Holt, you'll notice that the house is tilted on the lot. And I'm sure you'll be aware that's somewhat unusual. And why would somebody build a property initially in the 70s when this house was constructed at an angle and not parallel to the front property line? And the reason, Mr. Chairman, is simply this. The rear of the property, and excuse me for not taking photographs, the rear of the property is not only sloping, but it is steep in a southeasterly direction. And so the house was built at an angle to that slope to facilitate drainage and to take advantage of the level portion of the lot. And Mr. Chairman, whilst that's not a standard for the extension on the home, it is somewhat of a cause for the confusion of these experts, perhaps, in their mathematics to calculate where one corner might be if you simply added that 8 feet, I believe it is, out in front of the living room. The home is a modestly sized home, and in fact, in my estimation, most likely still the smallest home on the street. But because of the tilt, when the extension was put on, precisely the architect's drawings, it encroached upon the setback. Understand there's no excuse for the actual breach of the zoning regulations, but I'm asking this committee to take into consideration the peculiar circumstances my clients found themselves in, and the fact that it's now been 4 months vacant and still unsold, and somewhat of a hardship to them also. I'll be happy to take your questions, and I thank you for your time.
Thank you, Mr. Windsor. Are there any questions of the petitioner by the board? Yes, Mr. Ron.
Thank you, through the chair, Mr. Windsor. Thank you for your presentation. Can you briefly describe for the board the layout of the house? I'm interested in moving from the street towards the back of the lot, bedrooms versus common rooms.
It's a tri-level house, Mr. Chairman. You go in the front door there to the left of the garage, and you have stairs going up to 3 bedrooms and 2 bathrooms. You have stairs going down to the tuck-under garage. So then to the left, you have the living area, which simply comprises a living room in the front, behind that the dining room connected to the kitchen, and a slide-out door to the backyard where you look at the embankment. So the living room was very small prior to this, and indeed it certainly enabled the property to be marketed more easily with extension on the living room.
Are there any other questions of the applicant? Mr. Windsor, I have a couple questions. Do you have the packet before you?
Yes, Mr. Chair.
And if you turn to page 13 of the packet, which is kind of the overall aerial photo of the area, and there's been some discussion, and you had touched on the orientation of the house relative to the back of the topography, to the back, the slope. 2 comments or observations that I made, and just wanted to ask your opinion. It would seem like there's, with the orientation, it would be hard to observe the encroachment to the naked eye, I guess, or driving along the street. I realize I haven't driven the street, but I haven't seen the pictures. It'd be hard to tell where the encroachment is or isn't based on the orientation of the house and the road configuration. Would you concur with that?
Mr. Chairman, I did take photograph across the front of the house to demonstrate that it is very difficult in my photographs here, which I believe are near the front of that packet. So on page 10, you're looking down the street to the corner where the street turns north. You're looking from the eastern direction. And then on page 11 is looking east up the street from the west, and you can see the home behind. And I didn't sort of juggle my camera to make it look that way, but of course it's only the corner that is approximately 14 inches and, just 4 or 5 inches over what would have been an administrative over-the-counter variance. It's the corner only, not the entire living room extension, just the corner, because of the angle of the house. And probably the page 11 is a good picture for you.
Thank you. Are there any other questions by any of the other board members? Does staff have any questions of the
No, Mr. Chair.
applicant? Thank you. Thank you, Mr. Windsor. You have 1 minute for rebuttal, and we'll open this up for public hearing and see how much rebuttal is necessary.
Thank you. That opportunity would come later, Mr. Chairman?
Yes, I'm guessing it's going to come pretty quickly.
Okay, thank you.
Yeah.
All right.
With that, the public hearing is open. Is there anyone from the public wishing to testify? Anyone at all? Seeing and hearing no one, the public hearing is closed. Does staff have any rebuttal?
No, sir.
Mr. Windsor, you have a minute.
Rebuttal, Mr. Chairman.
He's indicated that he has no rebuttal. With that, the matter rests with the board. Again, could I have a positive motion from a board member, please? Yes, Ms. McKay.
In case 2014-0162, I move that we approve a variance from AMC 2115-010B. Is that what I'm approving a variance from? No, variance from AMC 2140-030G1 to allow a two-story house to encroach 1.2 feet into the 20-foot front yard setback. Subject to conditions 1 through 3 on page 5.
Thank you, Ms. McKay. Could I have a second to that motion, please? Yes, Mr. Ron, you indicated you would second that?
That's correct.
Thank you, Mr. Ron. Ms. McKay, would you speak to your motion, please?
I plan on supporting my motion. I find that the exceptional or extraordinary physical circumstance on this property is the steep slope in the rear of the property, which caused the angle of the house, and combine that with the fact that this request is in my view de minimis. So the first three conditions, or the first three standards, are met as a result of that slope, and standards 4 through 7 met as stated by the staff.
Thank you, Ms. McKay. Mr. Ron.
Thank you, Mr. Chair. I concur with Ms. McKay and staff with respect to standards 4 through 7. I also find the slope as discussed during the public testimony and what I feel also deduced from photos on page 9 of the staff packet from the adjacent lot, as well as the aerial photo in page 13 showing the slope, or excuse me, the alignment of the street. What I think bears away from the natural topography or slope lines that were discussed in the back of the property, weighing on the original positioning of the house as discussed, therein creating a physical circumstance with respect to standard 1. I find that that standard has been met, and subsequently standards 2 and 3 met as well. Also, for the record, reflecting the layout of the house and the addition to a living room on the front of the house, as opposed to, well, that's where the addition was needed, and that's where it occurred. Vegetation and the unique circumstances of the lot to the south also weigh in my decision on this matter, and I intend to support the motion. Thank you.
Thank you, Mr. Ron. Ms. Dole.
I agree with Mr. Ron and Ms. McKay as to the first standard, and with them and the staff as to standards 4 through 7. With regard to the second one, it speaks to the creation of an exceptional or undue hardship upon the property owner, and I wish to say that I'm not considering the financial hardship, but what I am considering is the small size of the house. If this addition had to be torn down, which was my understanding as to what would happen if the variance was not granted based upon some materials in the application packet. and given the maps showing the other houses in the immediate vicinity and the small size, I find that's the hardship that would be created based on the physical circumstances that have already been discussed, namely the steep slope that necessitated the angle of the house. So I just wanted to make that clear. And I'm more troubled by factor 3, but I think that again, I would speak to the reasons for the angle of the house, which was not a self-imposed factor, but resulted from the physical restraints of the parcel.
Thank you, Ms. Dole. Are there any other comments from any of the other board members? If not, please vote. That motion passes by a vote of 7-0. Again, the findings of fact will be based on Ms. McKay, Mr. Ron, Ms. Dole's comments. I do need to read for the record, every final decision of the board shall clearly state on its face it is a final decision with respect to all issues involved in the case, and that the parties have 30 days from the date of mailing or other distribution of the decision to file an appeal to the Superior Court. That brings us to our next case this evening, which is case 2014-0166. The petitioner is Dennis Marks. Is the petitioner here this evening? He has indicated he is present. Mr. McLaughlin, could you provide us with the sufficiency of notice, please?
There were 121 public hearing notices mailed on October 22nd. One response was received, and it was in support of granting the variance. Also, the Mountain View Community Council passed a resolution stating its non-objection to granting the variance. These are found on pages 34 and 37 of your packet.
Thank you. Could you proceed with your presentation?
The petitioner requests a variance from minimum yard requirements to allow an existing single-car garage to encroach 2 feet into the south side setback. Let's see. Yes. The garage contains 392 feet and is attached to the house. In regards to standard number 1, it does not appear to be met. There are no exceptional physical circumstances of the land that warrant the granting of the variance. Standard number 2 also does not appear to be met. There are no physical circumstances of the land contributing to the need for the variance. The original garage was constructed in 1958 and would have been a non-conforming structure for its encroachment. However, the original garage was damaged by fire and reconstructed in 1989 without a permit. Non-conforming structures that are damaged more than 50% of replacement cost at the time of destruction must be reconstructed to meet the required setback. Standard number 3 does not appear to be met. There's no peculiarity of the lot. The lot is essentially the same as others in the same zoning district. The need for the variance is the result of the petitioner's desire to keep the existing garage in its current location. Removal of the encroachment would require a major structural remodel of the garage. Standard number 4 is substantially met. The 2-foot encroachment into the 5-foot setback does not appear to adversely impact adjacent properties. The petitioner has provided letters of support from the 3 nearest neighbors. Those letters of support are on page 21 of your packet. Standard 5 is met. The requested variance is for a side setback, does not change the character of the zoning district, if the variance is granted, it would not allow a prohibited use. Standard number 6, the Building Safety Division commented that the building code requires structures closer than 5 feet from the property line to be fire protected. If the variance is granted, the petitioner should be required to resolve the need to make the south wall of the garage fire safe. With this condition, then the variance request does not appear to negatively affect health, safety, or the public welfare. Standard number 7 is substantially met. The existing garage encroaches 40% into the side setback. It appears to be minor. The department finds that standards 1, 2, and 3 are not substantially met and therefore must recommend denial of the variance. If after a public hearing the board finds that standards 1, 2, and 3 and all 7 standards are substantially met, then the approval should be subject to conditions 1 through 4 on page 6 of your packet. Conditions 1 and 2 are standard conditions. Condition number 3, obtain an encroachment permit from the right-of-way division for the portion of the chain link fence that is located in the North Bliss Street right-of-way, or remove the fence from the right-of-way. And condition 4 states provide fire protection to the south wall of the garage as required by the Building Safety Division. That would require probably the removal of the siding on that wall, and for fire protection to be put up, and then the siding to be replaced on that wall to make the exterior of that wall fire safe. And that constitutes less than an inch of sheetrock board along the exterior of that wall of the garage. Condition number 1 states this variance approval is from minimum yard requirements to allow an existing garage to encroach 2 feet plus an additional inch for fire protection into the side setback on the south side as shown in the as-built survey. So that's an explanation of where that phrase in the condition of approval came from. Thank you.
Thank you, Mr. McLaughlin. Are there any questions of the board of staff? Yes, Mr. Ron.
Thank you. Through the chair, Mr. McLaughlin, thank you for pointing out the consideration that staff made with respect to the potential additional inch needed. Can you provide the reference for that? Is an inch, in fact, going to be enough, or should the board consider granting 2 inches?
I spoke with the building safety reviewer who commented, and his name's Ron Wild, and he said that this type of his comments are on page 25 of your packet, and he said that the fire protective structural improvement is only about 1/4 of an inch, so 1 inch is more than enough.
Thank you.
Yes, Mr. Hart.
Thank you, Mr. Chairman. My question was related to Standard 2 and the non-conforming structures, AMC 21.06.02A. With this having been rebuilt a significant time ago, just wanted to confirm that municipal code was in place at the time this was rebuilt.
Through the chair, Mr. Hart, that's correct. That the required setback was in effect when the building was reconstructed, and information on this property can be found on pages 40 through 43 of your packet. The last 4 pages of the packet are the non-conforming rights determination, and I've put some arrows in to show sort of milestones or important dates. When you read the non-conforming rights letter, you know, the people that write these letters do a very good job of property research, and the information's not perfect, and sometimes they have to make assumptions, and so they use aerial photography by year and notes in different places, and they pull information from many different sources. It takes time and effort, but essentially there's, you know, they know that the original garage would have had grandfather rights had it not been damaged by a fire. And I think they point out that they're not certain of the amount of damage that the fire caused or the amount of improvement that was required to rebuild the garage. But at the end of it, the letter writers determined that the structure doesn't have grandfather rights, non-conforming rights for the encroachment, whereas the original structure would have.
Did that answer your question, Mr. Hart? Thank you. Ms. Dole.
Through the chair, the history that was just mentioned on page 41 has an entry for July 13, 2000, that when there was a building permit that was requested, and it looks like there's a specific statement about garage encroaches 2.1 feet into required 5-foot south side yard setback. A variance is required. Structure is not shown, and I guess I'm wondering why there wasn't any follow-up, or what happened in the year 2000 with regard to this, because it wasn't clear to me. So if you could clarify the statement, that item and what happened then, that I would appreciate it, if you can.
Through the chair, I did not prepare this letter. I think that this building permit had to do with an interior remodel. When you look at the photos provided by the applicant, it's quite a neat house, and I think it has been through some remodel and upgrades over the years, or, you know, at the time, 2000. And I think that it appears that the Building Safety Division allowed the interior remodel of the house to proceed and noted that there was an issue of the encroaching garage. I think that that's what that's referring to, but you know, I'm not certain. I'm just sort of reading it on the spot here.
Thank you. Ms. Eicher.
Thank you, through the chair. Mr. McLaughlin, I was wondering if you could look at page 13 with that aerial photograph and talk a little bit about what the neighboring houses have with respect to garages. It's a little unclear to me. I mean, I see what appears to be kind of like a back alleyway that you commonly see in older neighborhoods where the garage is situated behind the house. But it appears from the photographs that this garage is situated next to the house, and I'm just wondering, do other houses in the neighborhood have garages similarly situated, or are they behind? Some of these look like there's no garages. I just am not familiar with the area and was hoping you could speak to that a little bit.
I think it's a little bit of a hodgepodge. On this block, there are some single-family homes with garages situated in a similar fashion. But most of the properties are developed with multifamily housing. The other lots to the east, no, to the west, are developed with, I don't know if they're fourplexes or sixplexes. I think that the property owner could describe the development of the other lots better than I can.
Are there any other questions of staff? Mr. McLaughlin, I have a question, and I'm going to steal from former board member Marsh's question. We've got a case before us for a side yard setback. It appears that we've got comments from adjacent properties in support of the variance request. It's in my opinion, a good-looking, attractive house. Why should we as a board care about this? While I know it's a variance that's brought before us, is there, if the fire safety issue is resolved, are there other issues out there that maybe we need to be aware of besides what and how it's presented before us?
No, I think that you're correct. There are letters of support from 3 neighbors, the most affected neighbors, and it is a nice property in maybe a transitional neighborhood. It's one of the nicer properties in the whole neighborhood. Everyone has to play by the same rules, and for every encroachment, there's no staff does not have the ability to administratively sort of ignore the rules. We're bound by to enforce the code, and the code requires this 5-foot setback, and they encroach slightly into it. I think I've sort of noticed that sometimes builders, contractors will maybe in a rush because they're going from project to project or what, will rebuild a structure or a fence or a deck on the same footprint that it existed before. So if a deck's falling down, they will remove the dangerous structure, rebuild it in the same spot to a better condition, but maybe they never applied for a proper building permit for this structure that would be counted towards an encroachment, and maybe the original deck would encroached and would have been eligible for non-conforming rights, but the new one that was built in the very same spot does not. The zoning rules came into effect the zoning regulations came into effect with general area-wide rezoning at different times. In Mountain View, it was a long time ago. It was in the 60s. In Chugach Eagle River, it may have been in the mid-70s. So they came in at different times, and things that were built prior to zoning would be eligible for non-conforming rights. But this situation where a contractor, fixes a structure, improves it, and rebuilds it on the same foundation, but without a building permit, this one was caught.
Thank you. Are there any other questions of the staff? Yes, Mr. Ron.
Thank you, Mr. Chair. Mr. McLaughlin, I think I have a 2-part question. Hopefully you can answer at least 1.5 of those parts, and I'll reserve the other half for perhaps the petitioner. In looking at the photos on page 11 of the staff packet, if I have my bearings right, we see a fence line, the garage on the right side of the photo, and the neighboring property, which I think is to the south, on the left side of the property. Does staff know what the dwelling situation of that property to the south is? Is it 1, 2, or 3 or more dwelling units?
Through the chair, I can't recall how many units that one is.
Okay. And for the record, can you brief the board on the setback requirements and why there is a dimensional difference between dwelling units? I see on page 2 of the staff packet that the side yard setback in R2 is 5 feet for 1 or 2 dwelling units and 10 feet for 3 or more dwelling units.
Right, so the R3 district has different yard setbacks based on the number of units, and this is to allow a property owner the enjoyment of their property for, air, space, light, and more units is a more intense use, and the yard requirement goes up with the more units that you have in this zoning district. More free space apparently is desirable or required.
And for the record, the subject property is a single dwelling unit. Is that correct?
Yeah, the petition site here, the subject of this variance, is a single-family house. And you'll notice that the garage doesn't have it's allowed 2 feet of eaves encroachment, but it has no eaves. It just cuts right off at the wall.
Thank you.
Yes, Ms. McKay.
Through the chair, Mr. McLaughlin, do we know what the distance to the house next door is from the garage to the house? Is that other house right at 5 or further over? Or?
It's approximately 5 feet from the property line.
Okay.
So there's nearly 10 feet. Well, let's see. There's 5 feet from that property, from the wall of that house to the lot line, and we're dealing with an encroachment of 2 feet. So there's 8 feet between the structures.
Okay.
Although the eaves of one of the structures overhangs a little bit.
Thank you.
Are there any other questions of the staff? Seeing none, could the applicant come forward, please? And could you first state and spell your name for the record?
My name is Dennis Marks, 2 N's, and it's Marks.
Thank you, Mr. Marks, and you have 10 minutes for your presentation.
Thank you. Yeah, since I'm pretty disorganized, I just wrote something that I'll read, and I've been crossing off things as I've heard some things already presented. This variance process came upon me fast and unexpectedly, and I got a quick education and help from a lot of people, and I'd like to thank some of them. The Municipality Planning Division, who are helpful and professional, spent a lot of time figuring out what most likely happened to the property over the decades, spent time educating me and walking through this process. And I want to thank the members of the Mountain View Community Council, who were already mentioned, who took the time to look at the documentation, consider the case, and offer up a resolution. I'd like to thank my neighbors who gave me their opinions and their signatures and support. And I'd like to thank you tonight who took on the work and time required to consider this. On the application itself, I agree that standards 4, 5, 6, and 7 are fully met. I disagree that 1, 2, and 3 are not met and believe they are substantially met, and that the structures constructed before these ordinances were in effect and with the residents still in the original location eliminated any other possibilities for the reconstructed structure to be located. The lot, apparently the standard for the block at 50 feet wide, is still a very narrow lot and most definitely a confining element of the property, even with only the 25 by 25 foot house that sits on it and a 13-foot wide one-car garage next to it. And I hope that speaks to all 3 of these standards. I was looking through these tonight, and I listened to one of the links of a prior variance, and it seemed like some of the standards in 2 and 3 were separated from 1 and the 1 variance application that I listened to, and so I'll just say that with regards to 2 and 3, it would create an exceptional undue hardship. I don't think there's any way to get a permit to change the structure that's there. I think it'd have to be torn down, and I don't believe that it is self-imposed, since I've only been there since 2011. There was also the mention of the fire concern to other properties. I want to mention that the garage has been brought up to modern codes through the recent sale and inspection process. Most of the interior has been sheetrock, the wiring approved, and the panel GFCI protected by a licensed contractor. The home itself is concrete block to the roof and has a metal roof, so fire spreading to or from this property is less likely than if the home was built with more flammable materials. I think this is already stated. The packet mentions one letter from a neighbor. I also got statements of support from the 3 neighbors who will be most affected. Someone here asked about the home next door. It's single family. It's a Habitat for Humanity house that was built less than 10 years ago. And I know some of this because the person I bought the house from was a friend of mine who's lived there for 12 years before I did. So the 3 neighbors will be most affected by the demolition, none of whom believe a change of the property is in their interest. I think that even small garages are important structures in Anchorage in winter and feel that residences in Mountain View should have access to them. The garage is a very sturdy and attractive structure, and the home has gotten many compliments from neighbors and strangers on how the property looks. It is unlikely that any new owner could afford to replace the garage, and I think demolition will permanently harm the property. This is an attractive neighborhood where all my immediate neighbors take pride in their properties. Mine isn't the only nice-looking house in the area. They work hard to make their homes and yards as attractive as possible, given their budgets. Finally, I'm an advocate of statutes and rules, especially where we live very close to each other, like we do in Mountain View, and wish that the owner had not taken upon himself to make the decisions that led to this. But I also believe this is a well-intended and legitimate use of the land. For my neighbors, all want to see the new resident in the original intact home. Nobody wants a demolition project next to them, and all prefer an attractive garage over everything else that's likely to take its place if it's removed. And so for all these reasons, I hope that this variance will be granted. Thank you.
Thank you, Mr. Marks. Are there any questions of the applicant by any of the board members? Yes, Mr. Ron.
Thank you. Through the chair, Mr. Marks, one thing we haven't discussed are any potential safety or security benefits of a single-car garage. Can you speak to those, perhaps, with respect to the garage on this parcel in your neighborhood? Are there any benefits of note?
Safety and security?
Yes.
Well, you look at some of the other properties away from, I think the ones that are kept close to mine are very well maintained and very conscientious neighbors I have. If you walk away from this immediate area, you see houses that have vehicles and belongings strewn about a bit, and I'm afraid that might be what happens to this place if the garage is removed. And it's a 25 by 25 foot house, tiny, and there's no real other place to put things. And so I'm guessing sheds would go up, or things would just be left in the yard. And that could attract trouble.
Thank you.
Yes, Mr. Vig.
Thank you. Through the chair, Mr. Marks, if the variance were to be denied, and I think you've spoken to the fact that it would be demolished. Is that the option you see as the most feasible at this point?
I hate to even think of it, but it's a place where people who are getting loans, I'm selling it, and the people who are trying to buy it, and we had a woman just ready to move, and she was 3 days away from moving in when this hit. She had a VA loan, and that got denied. And people are telling me that other loans are likely to get denied too. So no one's going to have the cash to buy this. So if no one can get loans for it, the only solution I see is to tear it down.
Okay, thank you.
Are there any other questions? Mr. Marks, one follow-up question, and I realized you just, I think, answered it, but I'm going to ask it. As far as moving the structure, it appears, as far as building in a conforming location, it appears on page 10 of the staff packet, there's a photo. There's a basement, or do you have a copy of the staff packet?
I do. That's what I'm looking for right now.
Okay.
I know I've got it here. You want,
Here we
can you?
have
And I might be able to answer it without it.
And the photo that I'm referring to is on page 11 of the packet. It's your first color photo that shows the front of the house. There's a driveway.
Oh, here we go. Sorry. Okay, page 11?
Page 11,
Uh-huh,
the top photo.
right?
Those two, you have a basement on the existing house.
There is a basement, and those are egress exits.
Egress, the little, and I forget the term, the little,
We call them dog houses, but
yeah, okay, thank you. So in my mind, it would appear that if this were to be denied, and if you were to try to build the garage in a conforming location, you'd have to shift the garage 2 feet closer. You'd also have to shift the driveway 2 feet closer. That gets it pretty much right up against those two, the dog houses or the ingress-egress windows. Would that be about correct?
I think it depends on how close it is. Right now, the garage is back behind those. It's behind the dog houses.
Yeah. Yeah. But to shift it, to build the garage in a conforming location, in that same location, but to meet your setback requirement, you'd have to move it. I don't have my bearings here.
Right. I think I know what you're saying, and I don't think it would be a garage where you could put a car in if you had to make it any narrower than it is, which you would have to do.
Okay.
It's pretty slim right now. It barely fits a car.
Okay. Thank you. Are there any other questions? Yes, Mr. Ron.
Thank you, Mr. Chair. Mr. Marks, is there interior access between the garage and the house? I see a covered structure in between the two, and it's interesting to me. I don't quite know what's going on there. And
Yeah.
I'm curious as to whether or not the potential reconstruction of this garage, moving it 2 feet, would also affect that bridge structure between the two.
That's kind of what it is. We call it the breezeway, and it's sort of an exterior covered, just so you're not having to walk through the snow between the garage and the house. And that would come down. Yeah, that would have to come down.
Are there any other questions? Seeing none, does staff have any questions of the applicant?
No.
With that, we will again open the hearing up for a public testimony. Is there anyone from the public wishing to testify? Anyone at all? Seeing and hearing no one, the public hearing is closed. Does staff have any rebuttal?
No.
Mr. Marks, do you have any rebuttal?
No, thank you.
Thank you. With that, the matter rests with the board. Again, could I have a positive motion from a board member, please? Yes, Mr. Vig.
Mr. Chairman, in case number 2014-0166, I move that we grant a variance from AMC 2140050G to allow an existing garage to encroach 2 feet into the south side setback, subject to the 4 conditions on page 6 of the staff packet.
Thank you, Mr. Vig. Could I have a second to the motion, please? Yes, Ms. Eicher, you've indicated you would second that.
I am.
Thank you. Mr. Vig, could you speak to your motion, please?
Thank you, Mr. Chairman. I'm going to spend my time on standards 1 through 3 is I believe that staff has correctly analyzed the issues in standards 4 through 7, and I concur with their findings in those standards. And so, with regard to standard number 1, extraordinary physical circumstances of the property, it's I struggle with this one a little bit. I believe that the narrow lot that is that we're dealing with here, and the presence of the home on that lot that has non-conforming rights constitutes some physical circumstances that do limit the location of where this garage could feasibly go. And so I would like to hear from other board members, but I think that there's some conditions here that deserve some consideration. Standard number 2, because of these physical circumstances, strict application of the code would create an exceptional or undue hardship on the property owner and would deprive the applicant of rights commonly enjoyed by other properties in the same district. In this standard, I view strict application of the code would create an exceptional or undue hardship on the property owner in that in the years that I've been on the board, this board, we've heard situations where garages were in encroaching locations, and I think over time the board has come to view garages as a necessity for living in Anchorage, Alaska in the wintertime. And we've given quite a bit of leeway for the fact that garages are an essential component of living here. And so I believe that standard is met, that it would deprive the applicant of rights commonly enjoyed by other properties. Standard number 3, hardship is not self-imposed. And certainly this one, the applicant before us this evening did not rebuild the structure in its current location. I'm not sure how a person would even become aware that the non-conforming rights have been extinguished in a case like this, but I find it hard to believe that this is a self-imposed condition, and so I believe that standard is met, and I intend to support the motion.
Thank you, Mr. Vig. Ms. Eicher.
Thank you, Mr. Chair. I agree with the comments that my colleague, Mr. Vig, stated with regards to standards 1 through 3, and I agree with the findings of the staff with the balance of the standards. I think that with respect to standard 1 and 2, I'm similarly going to rely on previous findings by the board that the narrowness of a lot can be a basis for finding that there is some exceptional or extraordinary physical circumstances of the property, and that a garage is depriving one of a garage in Alaska would create an undue hardship. I find that the use of the subject property seems very efficient. It's not ostentatious. The fact that the adjacent landowners are supportive, similarly with the community council. I see the alternative of requiring the landowner to demolish the garage as not an acceptable remedy, and therefore plan to support the motion.
Thank you. Are there other comments from board members? Mr. Ron?
Thank you, Mr. Chair. I concur with board members Vig and Eicher and appreciate their comments with respect to the case. I similarly intend to support the motion for reasons previously stated. I would like to call out for the record an emphasis on staff condition number 4. We did hear from the petitioner that the house itself had been brought up to code, but did not hear evidence absolving the petitioner from condition number 4 with respect to improving the fire protection on the south wall of the garage. So I appreciate the condition as stated, but just want to emphasize it for the record. Again, I intend to support the motion. Thank you.
Thank you, Mr. Ron. Are there any other comments? Any of the board members? If not, please vote. That motion passes by a vote of 7-0. Again, the findings of fact be those of Mr. Vig, Ms. Eicher, and Mr. Ron. For the record, every final decision of the board shall clearly state on its face it is a final decision with respect to all issues involved in the case, and that the parties have 30 days from the date of mailing or other distribution of the decision to file an appeal to the Superior Court. That ends our public hearings portion of the meeting. Moves us on to reports from the chair. Just real quickly, Ms. O'Brien had asked that I call the municipal staff as far as checking on the status of any additional appointments, and unfortunately when I made that call, the answer I got was they didn't have any. So I requested that we try and fill those seats as soon as possible. Unfortunately, the comment came back, if we have any ideas, forward them to them. So anyway, if anyone has any ideas, let me know. Mr. Ron.
Mr. Chair, I do have a name, but she's a Canadian. I don't want to hold that against her, but am uncertain and would be interested in staff's comments to that effect. Are there any residency versus citizenship requirements for serving on municipal boards?
I think that she would just equate to 0.77 of a board member, or whatever the current monetary conversion is. But yeah. Okay.
It hasn't been an issue in the past. I know that.
I don't think that citizenship is a requirement for serving on the board. Interesting. Yeah.
I would encourage you to forward the name to Mr. McLaughlin, or I'm sure he'll forward that on to the appropriate
Will do.
entities. I wish it didn't fall solely on the existing board members to find additional board members, but that's been the case more often than not. Are there any other comments from any board members? We have, I guess just follow up, we have one case next month. Does anyone have any idea on their attendance plans for next month at this time? Does anyone know if they will be definitely gone? All right. I guess my last comment is I appreciate all the comments on the cases this evening. It made my decisions easier to make. I thought they were very well presented, so I appreciate that. If no other comments, could I have a motion to adjourn? Any objection? I think I needed a motion before I gavel. Mr. Ron and Ms. McKay. Mr. Ron made the motion, Ms. McKay seconded.
Thank you.